to prove on a balance of probabilities that he is a good candidate for bail. The state need not to lay down, but all the state have is to prove that they have a prima facie case. Therefore, it's not the test beyond reasonable doubt. The rest of the issues can be dealt with during trial. Further, in bail application, the state is allowed or permissible to the state to simply put its version to the witness. Our witnesses will come and testify about this and that. Just put their version to allow the witness to comment without necessarily putting any document to that witness during bail application. And in these proceedings, the applicant, that is applicant 4, on the issue being raised, that issue was already responded to. Further, this case, this court would like to refer to the case of Johannes versus the state. Is an appeal delivered on 7 April 2025, High Court of Namibia, where at paragraph 47, the following was stated. The court will just read the relevant paragraph. But the state is not obliged to show its hand in advance, at least not before the time when the contents of the document, must be made available to the defense. Therefore, at these proceedings, the state is not obliged to show the contents of the document because it's just a bail application. From the onset, the court indicated the court is only dealing with the bail application. The rest of the issues can be dealt with in the event that the matter proceeds for trial. Therefore, on that basis, the application or the objection is overruled.
Please,
Mr. Court, please.
Before you proceed, I just want to see the last question. The last question was about the threshold being 25 million, and he answered yes.
Yes.
We can proceed.
Now, Mr. Mulunga, on the document that was given to you by your lawyer, it's a document prepared by Mr. Bangamavo. I want to take you to page 272 of that bundle. 272.
Mr. Bangamavo's bundle.
Yes, Mr. Bangamavo's bundle.
We can proceed.
Your Worship, just before I ask my question, that document starts on page 259. It's titled National Petroleum Corporation of Namibia, Schedule of Authority, but the interest is page 272. Yes, are you on page 272, Mr. Mulunga?
Yes, I am, Your Worship.
Okay, I just want to read to you where it says procurement of goods, services, and in brackets as per board approved operational budget. Do you see that?
Yes, I see that.
And we have already established that for the purchase of goods about 25 million, you needed board approval. Is it correct?
Yes, that's correct.
Okay, and then was the purchase of the bulk fuel storage facilities in the budget for Namcor in that year of 2022?
So, Your Worship, There was a budget that was approved by the board for the 2022-23 financial year. And there were two budget votes. The one budget vote was for asset acquisition, and the other budget vote was for business development. So for asset acquisition, I remember well, it was 25 million, and for business development, it was 40 million in that financial year.
Are you in a position to show us that document that specifically relates to what you have just told us now?
No, I mean, I just remember, I mean, I don't have that document, but I'm sure it's a document that we can obtain from Namcor.
Are you also in a position to give us a document that shows that the purchase of the bulk fuel storage facilities was approved by the Namcor board as per schedule of authority or this document that I'm referring you to?
Yeah, maybe let me just explain how these things normally work in Namcor. So because there was a fuel supply agreement that birthed the asset purchase between Namcor Trading and Enercon Namibia, it was not deemed to be a new procurement process. So basically we had to go in and implement that agreement. The budget was prepared for asset purchases and for business development. That budget was approved by the board. So when I received the internal memorandum from Olivia Dunasti that says that, you know, the facilities have been budgeted for in the current budget, you know, because it was not a new procurement process where you had to go and procure assets from various people. This was to buy assets from one specific client that we've already entered into an agreement with. We proceeded then to take the money from two different votes, from the asset purchase vote and then from business development, because this particular transaction was actually both a business development activity and an asset purchase arrangement.
But Mr. Mulunga, my question relates to the approval by the board in respect of the bulk fuel storage facilities. Is there any document that you can show us, even if it's from business development as you want to call it now? Do we have a document that you can perhaps give to us to show that, well, the purchase of the bulk fuel storage facilities were actually approved by the board, even if it's from business development? Do we have that document?
Your Worship, the Namcor board does not approve individual and specific transactions or purchases that we enter into. All that they do, they approve a budget, right? And then we go and spend according to the budget that has been approved. So they don't approve every specific transaction or asset purchase, because that is the purview of management. However, what the board needs to approve is budgetary reallocations and things like that.
So if you are saying this was approved by the Namcor board, why did the Namcor board then cancel the agreement? There's a letter that was authored by Shiwana Deunyama. You are aware of that?
Objection, Your Worship. Before the witness answers that, I think the question is prejudicial and unfair. Why? Because when the witness testified yesterday, he told the court, when I left Namcor, the contract was still operational. But in 2023, when I was in suspension, an acting managing director in the name of she wanna cancel it. I don't know why they cancel it. So, Your Worship, I think it's unfair to ask that question to Mr. Mulunga because number one, he did not author that letter. Number two, he was on suspension, and you will not know why. Please support Your Worship.
Can you respond?
Well, I think you can answer because if it was approved by the board, I do not think it was necessary for them then to cancel the asset purchase agreement. It was cancelled because there was no approval. That is the premises of my question.
Maybe before you responded to Mr. Kasperi.
Yes. Bishop, the additional suggestion that it's the board document before the honorable court that informs us who the party cancelling the agreement was is also an unfair statement, Bishop. I mean, it's another thing if my colleague takes it from that letter and puts it to the witness as it comes from that letter, unless my colleague has other information that we are not privy to, Bishop.
Council, I understand you to say the agreement was cancelled by the board because there was no approval.
Yes, that's what I'm getting at, Your Worship. In fact, that is supported by what we are saying with regard to the charge of fraud against the accused party.
But then you put it to him differently. Can you then maybe rephrase your question? That from the state's position is that it was cancelled because there was no board approval.
Perhaps I can speak, I'm indebted to the court. Yes. So I'm putting it to you, say that the agreement that was signed for the sale of the bulk fuel storage facilities was cancelled because there was no board approval.
I don't believe that's correct. Yeah, I don't believe that's correct.
But
Although, I mean, I wasn't there. I haven't seen any information that suggests that it was cancelled because there was no board approval.
okay, but then you, as you are standing there, this document, you are aware of it up until now, even at the time that you entered into the agreement to purchase the bulk fuel storage facilities. You were aware of this document, even up until now you are aware of it.
The schedule of authority.
Can
Yes.
you just clarify which document?
The document, the schedule of authority, that is on page 259.
Yes, I'm aware of it.
I put it to you, sir, that when you entered into the agreement for the purchase of the bulk storage fuel facilities, you disregarded this document, the schedule of authority. You went against the schedule of authority, which was a governing document.
Any comment?
Yes, I have a comment, Your Worship. Obviously, during our activities, when we carry out these sort of transactions, we obviously try and make sure that what we do is according to the schedule of authority. But it looks like there might have been an oversight, I think from my colleagues, because there is a specific provision in the schedule of authority. I just wanted to bring it to the court's attention. It's 2.4 of that same document. Because what I said earlier was that there was an approved budget by the board. One budget vote of asset purchase had 25 million. The other budget vote of business development had 40 million. So obviously we are allowed to reallocate money from one budget vote to the other. So that is what we did, because 40 plus 25 is 65 million. So in those two budget votes, it was enough to basically make the purchase of 53 million. However, there was an oversight from, I think, my colleagues, and something that we didn't pick up, where it says reallocation of budget to or from a single budget vote is limited to 20% of the vote on a cumulative basis. And this is really what the oversight was. And this was an oversight really on an internal policy of Namcor that we only sort of picked up later on, and it's not something that is criminal, and it's something that I was disciplined on by the board, and it is one of the things that I ultimately lost my job because of an oversight like this. I mean, nobody is perfect. We all make mistakes. Yeah, I think none of my colleagues actually reminded me of this before we actually paid the money. And so the issue is not that the board should have approved the asset purchase itself or the fuel supply agreement. The issue is just that we were supposed to go back to the Finance and Audit Committee to actually get approval to reallocate the entire budget from one budget vote to the other to enable us to buy the assets. So that's really the oversight that I'm talking about, Your Worship.
But Mr. Mulunga, as the managing director, were you not supposed to do a due diligent job to ensure that what is stated in the schedule of authority was complied with before you entered into an agreement with Enacon to purchase the bulk fuel storage facilities?
Yes, I was. It was also the duty of, the people that report to me, obviously, to bring this to my attention. But as I said, yes, it was an oversight that, yeah, unfortunately, we didn't go back to the Finance and Audit Committee just to actually say, well, we reallocated this amount to this budget vote. Please just sign that off. So that's really the issue that we didn't, only thing that we didn't comply with the schedule of authority.
Now, say, I put it to you that you misrepresented to the Namcor board when you entered into the asset purchase agreement for the bulk fuel storage facilities, because, yes, you misrepresented to them.
No, that's not correct.
Your Worship, you well recall, and as per usual, you were being handled dismissively. To one of the charges, Your Worship, and I made a statement that, Your Worship, the state is playing hide and seek. We are being told a misrepresentation was made to Namcor. Your Worship, you will appreciate. I can, for example, refer you simply to Mr. Namanje's bundle, Your Worship, where the charges appear. Amongst others, count 2. You will note, Your Worship, that the charges simply say there was a misrepresentation made to Namcor. Now, Your Worship, when my colleague is putting this proposition to this witness, all of a sudden now, there is someone at Namcor being identified, Your Worship. When the charges do not do that, when we have previously raised this issue, I have specifically raised it, Your Worship. And of course, as per usual, we were dealt with dismissively. So, Your Worship, that's the unfairness that we were complaining about. Because now, the state keeps changing the goalpost.
May I respond?
I don't recall me mentioning a name. I say to Namcor. Namcor is a
Namcor board.
Said board.
Yes, Namcor board does not have a name. It's the board or Namcor. In fact, I think,
Your Worship, if I may,
You just,
the
let
board,
me just let
Your
him.
Worship,
in fact, on page 1 of that document, with respect to the count of fraud, where it says, whereas in truth and in fact he did not have the necessary authorization from the board, thus he could not enter into the agreement with Enacon Pty Limited.
You can raise, Mr. Casper was. Yes.
Your Worship, that's what we are saying. The state continues changing the goalpost. Nowhere in those charges does it say board. Your Worship, a
But
board.
he just read it out.
Let me
Did
see.
he
No,
not
Your
read it?
Worship. Please allow me to
No,
finish.
I'm just saying he just.
I'll get there, Your Worship.
Yeah.
What I'm referring to, Your Worship, is the misrepresentation that is alleged to have been made. And now, It is saying it was made to the board, Your Worship, when in fact the charges as they are framed simply speak of a misrepresentation having been made to Namcor. Your Worship, a board is constituted of a body of persons. So my colleague cannot continue to change the goalpost as they go along, Your Worship. That is unfair.
I understand. You just read board. Is it not on the charge? I just want to clarify that.
It is there, so
Where? Can you just refer us, maybe?
on the bottom there where it says he did not have, because that is the premise of my question. Authorization from the board.
You see,
Sorry.
Your Worship, this is misleading the court. And we are falling for it. We are hopelessly falling for it. Your Worship, let's read. Whereas in truth, and in fact, he did not have the necessary authorization from the board.
Yeah.
It does not say Namcor board, Your Worship.
In
It has
representation.
no specificity, Your Worship. In fact, the misrepresentation as it's presented in the charge is alleged to have been made to Namcor. Your Worship, you will recall, I stood up here and I raised this issue and I said, Your Worship, Namcor is an institution managed and run by a body of persons. No one is identified at Namcor to whom the alleged misrepresentation was made, Your Worship. But I mean, if the suggestion is now that later part, and we are going to fall for it, Your Worship, then there is a big problem here. Because this, Your Worship, does not even speak to a misrepresentation having been made to the Namcor board.
Your Worship, just to amplify on this objection, we all know from the evidence on record, undisputed evidence, the charges relating to asset purchase agreement. That agreement is between Namcor Trading and Distribution Pty Limited, and the witness, when he testified yesterday, he pointed out the board of directors of that entity, the subsidiary. Of course, for some strange reason, my colleague for the state thinks that there is no difference between a shareholder and a company, but that is for argument. So when they say Namcor, with due respect to your worship, without mentioning which Namcor they are referring to, definitely this is an issue which they have to deal with. When they drafted these charges, which is couched in a very confusing manner, they've made their bed, they have to lie in that bed. Please go to the.
Yes, can we just refer to the charge as they are? Yes, on that one. If it's saying Namcor, for now, just read Namcor if you're saying, then so that we, yeah.
Yes, the court pleases.
Please go to worship.
I'll proceed to another question. So, Mr. Mulunga, when you entered into the agreement for the purchase of the bulk fuel storage facilities, you were acting as the managing director of which entity?
Namcor Trading and Distribution.
But we have also established already that you were the managing director of National Petroleum Corporation.
That's correct.
Which is a which is the parent company of Namcor Trading and Distribution.
That's correct.
All right. Now, what is the purpose of the Finance and Audit Committee at the time that you were Namcor?
Yeah, is to make certain budgetary approvals that are within the schedule of authority.
And then they have to approve a budget, of course, it has to be made with your recommendation as well.
Yeah, well, the budget is approved by the entire board. The Finance and Audit Committee doesn't approve a budget. They have separate certain functions that they carry out. And one of them is for these environmentations or reallocations that would be necessary to carry out the functions of Namcor trading.
With your approval?
Yeah, with my recommendation, yes.
Or your recommendation?
Yes.
Now, I just want to understand something. Did Namcor Namibia Pty Limited, at the time that you entered into the agreement to purchase the biofuel storage facilities with them, was it ever disclosed to you that these assets were encumbered for a period of 15 years?
I do not believe that the facilities are encumbered, or unless you want to explain to me what the definition of encumbered is.
Well, they could not be sold for a period of 15 years. That's what it means. The question
No,
is,
it's not what it means. Sorry.
Council, just have the courtesy, please. Yes, the court is in order. Can we just maintain the decorum? Yes, please. When your colleague rises, the decorum dictates you just kindly and courteously just sit down.
Thank you.
Yes.
Bishop, and it's not an objection per se, but again, Bishop, if it is suggested as if this is coming from somewhere, it's only fair that we be directed to where the state is getting this information. Unless my learned friend will say, Mr. X will come and testify A, B, and C. But if it is suggested as if it's something that is before this court already, Bishop, I just want my learned friend to refer to us, to direct us to that portion of whichever document makes that suggestion, Bishop, so that we can adequately deal with it.
Yes, that is in order. Council?
I'm referring to the memorandum of agreement between Ministry of Defense and Namcor. I'm just not sure in your band, Your Worship, where. Mr. Namanje, Exhibit D1 is page 143.
That is in Mr. Namanja's bundle.
I just want to make sure. No, it's not that one. Let me just get it. There are two.
Your Worship, it will help if my colleague can look at the date of the agreement, because there are several agreements that were entered into. Then we can assist with where exactly it is. The loose one that you have, what's the date of the agreement? The loose one there, written confidential, through you, Your Worship.
May I make a counter proposition? I mean, looking at the time, we are fast approaching 1 o'clock. I'd like to afford my learned friend for the state this opportunity to just have a moment to check the document, and we can then possibly review it too, and that aspect can be dealt with.
I understand. Yesterday I informed you I have another bail continuation. Yes, so I was inclined that we go until 1:30 and then I can rush to Mungun. Yes. But Council, take your time.
5 minutes, Your Worship?
Yes, he can take his time while we are in session. Mr. Gaib, you can assist with this document of yours. I know you know where.
Yes, we are just comparing the agreement. I think we found the page, but we just want to make sure it's
Okay. Yes, I have confirmed with the colleagues from Bungunda that we are set for 1400 hours.
page
Which same document?
143, it starts from 143, but the interest is page 147. It's exhibit D1.
Councils, are we there?
Yes,
Yes, yes, yes, Your Worship.
Article 2, duration.
So which page?
The document starts on 143, but I'm interested in page 147.
There, Your Worship.
Article 2, do you see that?
Article 8.
And I'll read it to you. It says that this
Article-
agreement shall
Oh, yeah, this agreement shall commence upon the date of signature hereof and shall remain valid for an extended period of 15 years. The agreement shall be, which is extendable by way of written notice delivered by either party at least 3 months prior to the expiration of this agreement.
Yes, so that's where my question is premised on.
Your Worship, that's exactly the issue.
Yeah.
And we should be fair, Your Worship, and we should not read things selectively and read them to impute a certain meaning to things that are what they are. Your Worship, no way will you appreciate, having read Article 2, that any reference is made to assets being encumbered and assets not being able to be sold for a period of 15 years. It's quite straightforward, Your Worship.
Yes, Council, I think it's in order. Mr. Yes, Casper has put it correctly. Yes, the word used incumbent is not appearing on Article 2.
Neither, Your Worship, is the suggestion that these assets cannot be sold for a period of 15 years.
Advocate, any response?
Well, I'll put it differently. These objections will not derail me. So,
The
I'm
council,
saying
we have already, councils, just, yes, can you just kindly sit down? Before you proceed, Advocate, from the onset or at some point, I have informed this court that objections will be raised at any time during the proceedings. It's the right of each and every council to raise an objection at any point when they so feel. And the court will make a ruling. Once the court makes a ruling, the matter must proceed. All councils, seasoned officers of this court, that is how the decorum works. So don't take it on any of your colleagues. They are simply within their rights.
Thank you.
Yes, please.
So, Mr. Mulunga, it says the agreement shall remain valid for an extendable period of 15 years. We're in agreement, that's what it says.
The agreement between Enacon and the Minister of Defense, yes, that's what it
Yes.
says.
And then it also further says the agreement shall be, which is extendable by way of written notice delivered by either party at least 3 months prior to its expiration of this agreement.
Yes.
Okay, so my question is, did Enacon inform you that there was a valid agreement between them, meaning Enacon, and the Ministry of Defense, which was valid for a period of 15 years?
Yes, Your Worship, and that's exactly the reason why we were comfortable to enter into a fuel supply agreement with them and an asset purchase agreement with them, because we knew it was backed by this agreement with the Ministry of Defense. Otherwise, we would have done it.
Okay, but then the agreement that you entered into, that is the center of contention here. We are not concerned about the fuel supply agreement. What we are concerned with is the asset purchase agreement. Let's just get there in the first place. Do you understand our position?
Yes, I understand.
So I'm asking you, what does that mean for you if there was an agreement valid for 15 years?
But this agreement has nothing to do with the asset purchase agreement. This is an agreement between the Ministry of Defense and Namcor, which is totally talking about supply of fuel management technology. Yeah, this is what this is about. It's got nothing to do with the asset purchase agreement that we signed with Namcor.
So
And this also does not in any way preclude Namcor from actually entering into an agreement with another party in respect of its assets that it has bought. Yeah, nowhere do I see that it says, this agreement, it says, because of this agreement, Namcor is not allowed to dispose of its assets.
So in other words, when you entered into the agreement, you knew about this clause, specifically clause in Article 2, you knew about it.
Again, Your Worship, I don't see how this Article 2 is relevant. This article is just talking about the duration of 15 years between the agreement between Ministry of Defense and Namcor, that it's going to be for 15 years and it's extendable by way of written notice.
Okay, still the question being, did you know about that clause, Article 2? That is all I want to know from you.
No, I wasn't privy to this agreement between Namcor and the Ministry of Defense.
Did you ask Namcor as the managing director of National Petroleum Corporation?
No, I didn't see the need of actually seeing this agreement because it has nothing to do with the work that I was doing or the contract discussion that we were having with Namcor.
I just want to, sorry, before you proceed, not an objection, just to assist the court and my colleague. Keep on repeating as the MD, Managing Director of National Petroleum Corporation. But we all know that he said he was ex-officio Managing Director of Trading and Distribution. He's the director. He's the corporation.
Yes.
While we are still at the asset purchase agreement, I just want to understand from you the sketch that you are trying to show us is that Namcor Trading and Distribution and Namcor are different entities. That is what you are saying.
It was not what I'm saying, it's what the facts are saying. It's what,
Okay.
yeah.
Now, in terms of acquisition of assets, did Namcor Trading and Distribution and National Petroleum Corporation, which is Namcor, the parent company, have different policies from each other? Did they have different policies?
No, like the schedule of authority, for example, relates to both Namcor and Namcor Trading and Distribution.
So in other words, they didn't have different policies with regard to acquisition of assets, the same policy?
Well, the schedule of authority policy,
Yes.
is a policy of the National Petroleum Corporation of Namibia.
Yes.
It applies to it and its subsidiaries.
But yet you are saying it's different entities, but they have the same policy. Wouldn't it just make sense that if it's different entities, like you are saying, each would have different policies?
No, it's not how it works.
Your Worship, sorry to interrupt the witness.
Yes.
Your Worship, I'm going to try and be very respectful to my colleague when I make this objection. If some of us do not understand that juristic entities can be separate and have separate registration numbers, we cannot keep putting this to the witness when he answered that he himself, who's not even a lawyer, understands that the two companies have been registered, they have two different registration numbers. They are juristic entities capable of being sued and suing, entering into agreements We can't keep putting these statements to the witness if we don't.
Ms. Gilbert, I must stop you there. I understand your objection, but that is not going to the heart of his issue. His issue is whether the two different entities had the same schedule of authority.
And the witness said they do not have. Then he proceeded, and this is why I'm objecting. He proceeded to say, if they have the same policy applicable to them, how can you please persist that they are two separate entities? That is why I'm objecting. That it is incorrect for this witness to please being asked the same question again that has been answered, where he illustrated that it is two separate juristic entities with two separate registration numbers.
Yes, I understand you, and respectively, I find no merit in your objection. It's overruled. The answer has already also been answered. We can move on.
Your Worship, I don't mean to disrespect, but my colleague hasn't even answered to my objection, and the court is overruling.
Yes, I understand that. I raised it with you that what you are saying is not what he is saying.
Is the court now answering on behalf of the state, Your Worship?
Counsel, I put a question to you that your question or your objection is not going to the issue.
As
The
it pleases
issue
the
was
court.
that the two different entities but having the same schedule of authority. That was his issue. But you are going to the two separate entities with two separate registration numbers.
As it pleases
Yes.
you.
We can proceed.
Now, Mr. Mulunga, there was an aspect that you testified yesterday with regard to Husabmine. Do you recall that?
Yes, I remember.
Yeah. You indicated in this court that similar assets were taken over for the purpose of supplying fuel to Husab.
Yes, that's correct.
Can you clarify who transferred ownership of these assets to Namcor?
Okay, as I stated yesterday, those particular assets at Husab Mine used to belong to Engine, because Engine is a petroleum company, fuel supplier. And Engine used to have the tender to supply Husab Mine. But when their tender ended, the Husab Mine called for new tender, and Namcor won the tender. So when Namcor won the tender, Namcor could not simply continue supplying the mine or supply the mine into the assets of Engine. So Namcor had to buy those assets from Engine so that it could continue supplying the mine. That's what I said.
Okay, what assets were those?
It's basically similar assets, bulk fuel storage facilities, in large tanks and pumps and, basically similar type of assets. It's assets required to supply a customer.
Just enlighten us. What documentation was provided at the time of transfer of those assets?
No, I cannot remember fully, but I do not believe it was a whole suite of documents. I mean, it's as long as Engine could prove that they were the owners, I think it was enough for Namcor. I mean, they were the owners, the insignia were all over the facilities, and it was tight. Everybody knew that Engine was the supplier, so there was no dispute there who the owners of those equipment were.
Just in context with Article 2, from the document that appears on 143 of the bundle, but of interest is page 147. I just want to clarify or to understand something from you. You agree with me that the fuel stations or the bulk storage facilities were in the premises of the Ministry of Defense?
Yes, in the various bases of the Ministry
Yes.
of Defense.
Okay, and then would you agree with me also that ownership of an asset in this regard, because it says, let me say, ownership of an asset passes when you have fully paid for it?
No,
Let me put it basically
I
that.
don't agree.
Okay, let me put it this way. When you own a car and you are still paying for it with the bank, whose car is it? Is it yours or is it for the bank?
Well, let me answer it this way, Your Worship. If you decide to sell that car, you can still sell that car, even though you still have a bond with a bank. So you can sell the car and then repay the bank. So it's not a problem. I mean, it's almost like a house. I mean, yes, it's owned by the bank, but it's registered in your name. The bond is registered in your name. So similarly, it's the same here.
So then on that premise, what do you make of the aspect of saying it shall remain valid for an extendable period of 15 years? Why do you think such a clause was there?
I don't understand your question, your Worship. The duration, the clause that you are quoting is the duration of the contract between Enecon and the Ministry of Defense,
Yes.
which is a totally different agreement, and I don't understand how it's applicable to the asset purchase agreement. I really don't understand.
No, I'm just asking you in context of this agreement. You just have to answer. If something says, as the document says, it shall remain valid for an extended period of 15 years. What does that mean to you in layman's terms?
Counsel, before you proceed, it appears from the record that you put a question to the fourth applicant that it was valid for 15 years, and he responded nothing to do with the asset purchase agreement, nor did that preclude Enecon, excuse me, to enter into an agreement with any other company.
Yes.
So I'm just wondering whether that is not the same question being asked about 15 years, which he answered already.
Yes, Your Worship. Maybe before
Yeah.
yes, Your Worship, with due respect, I don't know where we are heading to, because as his Lordship, his Worship mentioned many times from day one, this is a bail application for applicants who is in custody. Is he now driving a message to this court or to us that applicant is in custody because he did not understand that clause, Article 2? Is about your worship. I don't need an answer from you.
We can proceed.
I'll move away from that aspect. Now, you said a person called Victor Simaneka Malima. Do you know him?
Yes, I know him.
How do you know him?
I know him because he was one of the few purchasers at Namcor when I got there. Or I became field purchaser, owning one or two companies that was doing business with Namcor.
Did you have a personal relationship with him?
Not at all. Yeah, there's a business relationship.
You've heard during this case or this bail application that the person Victor Simaneka Malima bought you a motor vehicle. Did you hear that? An Audi?
I understand where my colleague is coming from. But just for fairness, no witness came and gave such testimony. But I assume my colleague is probably referring to the charges where the state has alleged the purchase of an Audi vehicle.
Yeah.
If my colleague puts it as such, there's absolutely no issue. But if it is put as if someone came and testified about that is wrong.
Advocate?
Well, in fact, yesterday, counsel for the applicant actually put it to him. So I'm basing it on that premise and also on the charges that the accused person.
Yes, it's
Yes,
in
Your
order.
Worship.
Yes,
Yeah.
Counsel?
I'm not a witness, Your Worship. I did not testify to that effect. I simply read down to the charge,
Yes.
which involved the motor vehicle.
Yes. Okay, we can proceed because he's saying it's relating to that charge, and he has already testified on that aspect. Any comment? Or maybe you did not finish. Okay.
Yes, I'll comment on that. Now, say I have a document here which was also disclosed to your lawyer, Mr. Bangamago. I'd like just to give you this document. It's a document from Audi Center.
Your Worship, and of course the court has made rulings on these issues. But Your Worship, you will remember yesterday when the discussion of that document emanated. All of us here agreed, Your Worship, that it's not legible. And it was left there.
Yes.
No attempt was made to provide us with a better copy. No opportunity was given to the bail applicant to forthright deal with it in anticipation of what may have been posted. So, Your Worship, we are asking for fairness. We are asking that the applicants before you be treated fairly.
Yes, advocates, if I
It's the
understand,
first page, Your
it's
Worship.
the first page, but if I understand Mr. Castade's earlier submission, it was that if, for example, we are saying there's a witness who is coming to testify, or if you put it generally from the charge, that this charge relates to that, do you have any comment? Then they have no issue. But they only have an issue if you are putting that document to him, because it was not legible.
I think it was a premature objection because I'm still getting there. I have to get to the document first before I get to that. And I think counsel for the accused must also just honestly put correct facts, because what is not legible is the first page, but everything else is clear. So I do not see how then they can object that I cannot put questions to this witness with regard to the document, because that has been done from the onset. So what is the basis of the objection?
Your Worship, all I'm saying, the document was dealt with.
Yes.
As we said here, even you, Your Worship, we accepted that parts of it is illegible. We asked the state to produce better copies. They said themselves they are unable to do so. Your Worship, the unfairness complained about here is that someone should be now presented with a document that even he could not deal with when he was giving his evidence in chief. Because we accepted when the state was unable to provide us with a clear copy, we accepted that there is the end of the document, Your Worship.
Yes, and counsel, I think the issue has been settled already. Yes. They have no issue. The defense, I understand the defense, if you put that question generally on the charge, there is no issue. But because that document, it came up and for some reason, it was not clear even to court. The impression was that the whole document was not legible. There was no clarification whether it's on the first part or the second part. But what we do now, you can put the question to him generally about that issue based on the charge.
Your Worship, I have to respond to that with respect, of course. This document that I have was disclosed to Mr. Bangamago. And the only part that is not legible is the first page.
I understand, counsel, but you remember when that issue rose,
Yes.
the court was under the impression the whole document was not legible. Just a minute, you did not put it, it's only the first part. It was just said it's not legible and the document was put. But there is no issue. You put the general question to him without referring to the document. That is what that is the argument. Yes, because the court understood that is why the document never came forth, that the whole document was not legible. Yes. But as I've indicated, you put your version to him because that issue was discussed. So generally, within the charge, you can proceed.
The investigating officer in this case will come and testify that Mr. Victor Simaneka Malima bought a motor vehicle in the name of Hileni Kamati. He bought it, Victor Simaneka Malima, but it was registered in the name of Hileni Kamati. And thereafter, that vehicle was given to you. What is your comment?
Well, my comment is, as you rightly posted, Your Worship, the vehicle was bought by Mr. Simaneka Malimi, and it was registered in somebody else's name. It's not my vehicle, it was not registered in my name, so it's therefore not my property.
In fact, we have documentation, and the investigating officer will come and testify that you had actually booked this guy at Audi Center for service, and you signed for the documents for the service thereafter.
That's correct, Your Worship. However, that does not make it my vehicle. I had taken the vehicle to the service because I had driven the car for 2 or 3 days, and Mr. Malima asked me to go and drop it on his behalf because he was taking a flight to Namcor. So that's what I did. I gave my details and I signed for it and I went to pick it up. That's all that I did.
So in fact, yesterday you were not truthful when you said you have no idea of this car that is mentioned in the charge. And I will be
Yes, sir.
specific.
Objection, my worship. The record will show that the witness will say, I'm not the owner of that car. Please,
Any comment?
Well, he said he has no idea of the car, and now he's saying he took the car for service. So are those not contradictory statements?
But Your Worship, the charge says the car was bought for him. If a witness having been put with a charge suggesting that gives such an answer, Your Worship, there can be absolutely nothing contradictory about it.
Yes, the objection, if it's an objection, Mr., the court will allow the question that you are contradicting yourself.
No,
From yesterday.
I'm not contradicting myself, Your Worship. I did say I was not the owner of that vehicle.
And the investigating officer will also come and testify that this car was actually bought for you because of the dubious circumstances under which you had sold, actually bought the bulk fuel storage facilities from Namcor.
I have no comment to that.
And in fact, the investigating officer will also come and testify that the money that was received from Namcor to Eco Trading, which was owned by Mr. Simaneka Malima, was also the same money that was used to purchase this same motor vehicle that was eventually given to you.
I have no comment to that.
You just slow down.
I'm not aware of those facts.
Yes, it's about 1:30. Another court to attend to at 1400 hours. So by agreement, do we then roll the matter to tomorrow? Yes. What is the time? Do you have any other time than 9? 9. Yes, we start at 9 in the morning.
Can the court just, I just want to check.
Yes, please.
Unfortunately, I do not have it, but I will let the court if I have another case tomorrow. But, I'm just not really sure. But if I'm available, I'll be here at 9.
Then that is in order. Say you are still under oath. The matter is then rolled to tomorrow to proceed at 9.
Yes, it is the court.
The court adjourns.